Hello, my name is Brett Bendistis, and this is a video lecture on writing motions, which is a very important part of any lawyer's job. And if you are a paralegal and you're able to write motions, I think that you have a very good value to the person you're working for. So I think that this is the kind of thing that is worth developing in practice to get better at, because I think that it's a good skill to kind of put forward with you. I should note that the first job I ever had in the law, so I graduated from college and then had an internship at a law office. And the first thing they did was say, hey, write this motion, right? You're college educated, I'm sure you can figure it out. I had like no legal experience. And when I wrote it and I gave it to the lawyer, the look on his face was, and I think he even said this, he was like, this is completely useless and we don't have anything to do with this because it's not in the form that we're looking for. And I think that what I learned there is that like there is a style to how these things are done, although they seem easy. So although it might just seem like numbered paragraphs, what's the problem? How hard could this be? There's a little bit of skill to this that I think is worth vetting out and noting to make sure that this is a practice that your motions look common to the place that you're working for. The thing I want to note about motions, and I think is really important to kind of pull together, is that the motion is a request to the court for some kind of action. Essentially, you are asking the court to doing something. You're not allowed to ask the court for something directly. That's considered an ex parte communication. So you can't just like call the judge and be like, Judge, I have a problem, can you do something? That you always have to make sure that something is kind of a general communication on the record. That's going to come into focus a little bit later on, the last point I have on this PowerPoint slide. But I just want to note the fact that if you want the judge to extend time, if you want the judge to take some kind of action, if you want them to move something, you have to file a motion that includes the requisite components. So that's the point about this is almost seen as like a permission slip from the court to do something. They ask the court to do specific actions to a related case, right? So you've got housekeeping motions, which are like, can we have more time? Can you tell us when we're supposed to be at court? And there's more substantive motions that are dispositive motions, motions that just like end the case, motions to dismiss or motions for summary judgment. So the key thing with this is that this is a form that takes a lot of that has a lot of stuff. You can do a lot of things via motion. So to know the different kind of importance here, I think is worthwhile to get a structure of how you do something. When it comes to the general form, they are a formal court document, so it files Rule 11, which requires that it is signed by a lawyer. Rule 11 is something that requires the court, that a lawyer does something that's their action. So it's the lawyer's certification that everything's like good, for lack of a better term. And then finally, most motions require 3 documents. It is a proposed order, a certificate of service, and then a notice of motion. A proposed order is just essentially something you're giving the court that says, and there's normally a very specific form, which will say something like, based upon considerations of this motion and any responses hereto, this motion is hereby denied or granted, and then there's a signature line for the judge. The idea being that the judge would just sign it and then send it off. But commonly, what the judge does is like hand write extra things, or they might write their other, write something additional. So your order should usually be just standard, bare bones. Let the judge add the things that they need to add unless they've told you otherwise. A certificate of service is just basically a verification saying I mailed this to the other lawyer. There's usually a form that you can find on your court website. We're going to be covering, the value of court websites and rules kind of in other lectures. So if you're not sure where it is, there should be a form section, usually on almost any jurisdiction's website. You can get it from there. A notice of motion is just saying if the court wants to hear this motion, this is the day that we're going to be presented before court. Again, it's usually required to be included in your motion, even if it's something as simple as, we're going to do it at the earliest possible date. So normally you call the court and ask, but that is also not required. The necessary elements of a motion. Now, motion, again, I can't cover everything concerning motions here because it's a very wide-ranging practice, but I do think there's a few very key things that are worth noting. The first is that the case caption is always going to be at the top of your motion. It's usually party versus party, the case number on the right-hand side, and there's usually like parentheses or semicolons all the way down the middle, right? So that's a usually general form. You'll take it from the initial case, complaint, or the answer. So that's a topic that you can just take right up from the heading. The facts section in procedural history. Normally when you're writing something, you just want to briefly introduce what's going on for the court. Normally, and this is my preference, right, is that if I'm writing any kind of motion, I will usually tell the court, this is a complaint for blank, it was filed on blank. right? So this is who I am. This is sort of when the case was filed, and this is what it's about. And just like, who are the parties? Very, very short, at most a few sentences. I would say that you should be able to limit the fact section and procedural history to one short paragraph. This is the plaintiff, this is the defendant, this is when the case was filed, that's it. Usually you've got time in other sections to do it, but one of the key things about motions is most motions are limited to 4 pages. Why that's important is it requires you to limit your writing, not to expand it. I know like the general idea of writing is like, how do I add fluff to this? Whereas I found that writing motions actually helped me out because it made me reduce my writing and really focus on what was most important. And I think that's a good practice here with motion writing because you want to keep it short, not go too much. After that, you've usually got one paragraph that is a standard of review, and that's for dispositive motions, motions that end a case. And this is just a general review of what is the standard. What is a motion for summary judgment, right? It is there's no material issue of fact. The proponent is entitled to judgment as a matter of law, right? This is a section where you'll probably have a set paragraph for this, where I don't think you need to be developing this section new for every motion that you write. You're allowed to sort of take something from an old motion and put it here because the standard is the standard is the standard. Unless you're really getting fancy with it, and you can sway it to your side a little bit. Like if I'm filing a motion for summary judgment, I'm always like, summary judgment's super easy. And if I'm opposing it, I'm like, summary judgment is impossible. And that's okay, right? Because you're trying to present something that gives the court an idea of either how easy or hard it is to contest something. The big thing of noting like the body of the motion, I find a good rule is when you're lost, rely on IRAC structure. When we talk about putting something in numbered paragraphs, right? So you'd have the first numbered paragraph, facts and procedural history. Second numbered paragraph is the standard of review. At that point, I will often do something of like third paragraph, the big chunk of law, fourth paragraph, these are all the application of the facts to that numbered paragraph, right? And then if I've got another point, this is my fifth paragraph. Sixth paragraph if I'm changing gears into something else. So when you're talking about numbered paragraphs, this is a very strict breakdown of where are you breaking course with your discussion. If you're changing the topic, change the topic in a way that makes sure you are breaking rank with it. And I think that when we're talking about IRAC, issue, rule, application, conclusion, the last sentence of every numbered paragraph should be something that tells the court what you're doing, right? If you've got a lot of rules and then an application, that last sentence should be, this is why I'm right, this is why my motion should get granted. Reaffirm your answer over and over again, but make sure that each thing is from there. If we're talking about, I did a previous lecture on multi-issue IRACs. This is the kind of place where I think this is a good description of it. If we're talking about right under the standard of review, that third paragraph would be something along the lines of like, what are the general rules for a statute of limitations? Extension under the time of discovery rule. A hypothetical where a person doesn't know they're injured until later. That first paragraph would be, this is the time of discovery defense. These are the elements. The next paragraph would be, this is whether someone's blamelessly ignorant. Rules, application. Next paragraph, this is whether an inherently unknowable injury, and this is why it's true. And then finally, this is when the case should happen. So you're breaking it into individual elements of saying the reader knows this is an important paragraph, this is my point, this is my conclusion. Make sure that every paragraph has a point to it and that is numbered in the way of the samples that have been provided on Blackboard or Campus Cruiser or whenever. So making sure that you're having something that is really relevant there and included is in furthering that idea of clarity and conciseness, right? So this is a shorter version. It's not something super long, but you want to make sure that your best points are highlighted, your conclusion is reaffirmed throughout the paper, and it takes the same form as something from before. And as always, when in doubt, rely on your IRAC. Thank you guys very much for listening. Again, I have many lectures on YouTube. You can search my name that's on there. Also, I have a podcast that is the Citizen's Guide to the Supreme Court. You can get it on iTunes or wherever your podcasts are provided. Thank you guys very much for listening, and I'll talk to you again soon.